Hello everyone, my name is Anna Rawat and I would welcome all the participants to the training session of MediateGuru's second virtual international mediation competition 2022. Hope you all will have a delightful experience and will learn a lot by participating in this competition. To familiarize you with the insights of this competition and the world of mediation, we have with us today expert mediator and the trainer for this session, Ms. Kathleen Ruan-Leedy. Ms. Kathleen is a mediator at Pierce County Center for Dispute Resolution. She is the first court jurors of US. She is a former divorce mediator at Norfolk Probate and Family Court. She is a former courts and training coordinator at Family Services of Central Massachusetts. She is a former summary process mediator at Quincy District Court. She is a former small claims and divorce mediator at Plymouth Family and Probate Court. She is a former small claims and summary process mediator at Cape Mediation. Ma'am is a former executive assistant to CFO and VP at Ram Power Corporation. She is a former health educator at Greencastle Antrim School District. She studied Masters of Education at Shippensburg State University and studied Health and Physical Education K-12 at Sheffield University. We welcome you, ma'am. Participants are requested, if you have any questions, please do write us in the chat box. Ma'am will definitely be taking up the questions. And please do feel free to interact through chat box. So now, ma'am, over to you. Thank you so much.
Thank you so much, Anna, for that kind introduction. That's a lot of formers in there. That must mean that I'm older. I've had time to do a lot of former things. Let me start this presentation and also offer, hang on one second, let's get this, offer my own welcome. I'd like to thank, it's tournament time. I'd like to thank all the judges and students and participants and helpers and coaches, over 48 teams in this tournament this year. It's MediateGuru's second virtual international mediation competition, as Anna had mentioned. And there's a lot of work that goes into tournaments and a lot of energy and excitement. And with this training session, I'm just going to ask that you all relax. We're going to go through this in a very relaxed fashion. And I'm going to do a short keynote speech, and then we're going to go ahead and get started. So my keynote speech would be about these mediation skills, how they enable peace at our mediation table, but they also enable peace within us, which then can be offered to the world outside of us. So I'd like to talk about that there are many topics to discuss, of course, in a keynote speech in regard to a mediation tournament, but I want to discuss peacemaking and building your confidence, especially in these tumultuous times. And I just want to take a pause at what's happening around the world. It's horrific. All the conflict that has risen to the level of destruction of people and things. And I just want to take a slight pause and acknowledge that there's a lot of people suffering right here and right now. So if we can just acknowledge that, I'd really appreciate it. With that, I want to just tell you that the very skills that you're going to use to compete with this next several days are the same skills that you can use to create peace and harmony in your personal lives. You can create and retain peace within yourselves, around you, and permeating into others. So let's take two common mediator statements or client advocate statements that can be used at the mediation table to create some clarity. One of them would be, so if I heard you correctly, you said, and then moving forward to what you said. Another common statement would be, thank you for your honesty, and this is what I heard you say. When we take those mediation statements from our mediation tournaments and we use them in our personal lives, we're seeking to understand awkward moments in our lives first, what someone has said first, before we launch into our response of what we want to say while they're saying something to us. This is the selfless process of mediation that we can use in our personal lives, because mediation is a selfless process that seeks clarity from the other side first before we decide to talk about what's important to us. When we do this, we can become very proficient in handling conflict in our personal lives, which creates harmony in our lives. It also allows us to grow with our skills of communication, which leaps us into a further contentment because it builds our confidence. So with that being said, as the keynote speech, I'd like to welcome all of you to enjoy the tournament, make new friends, compete to the best of your abilities, and please choose one mediation skill to use in your personal lives as you move forward in this tournament and after this tournament. I also am judging the finals, so I'm looking forward to the teams that I'm going to meet in the finals, and I wish all the other teams the best of luck as you move forward. So let's go ahead and move into what Mediate Guru is doing in June. If you'd like to know more about the world of mediation, there's typically around the world a 40-hour, 32-hour to 40-hour basic mediation class that gets taught to begin your journey as a mediator. Mediate Guru will be offering this class in June, and their certification has been accepted in the States and other countries around the world. They truly have an international 40-hour basic mediation training class. All are welcome. Mediation Process in a Nutshell is the name of the slide deck, and we're going to go ahead and look at it. If you don't have your judges' scoring sheets, please go ahead and get them in front of you. As judges, we are scoring you based on the parameters of what's happening in this tournament. You also may want to consider your rule book and your CI. As judges, we have to score you on the confidential use of confidential information and how you paid attention to the general facts. So you may want to make sure that these three arenas are forefront in your mind as you start to compete in this tournament. Let's start with the biggest dilemma at the mediation table. The problem, the dilemma that communication is actually taking place. So with that in mind, as people at the mediation table, you need to have accuracy, is how I train mediators. The search for accuracy and the need for accuracy at the mediation table is imperative. So allow yourselves to be correctable. Just relax. If someone says, no, this is not what I think, or no, this is not what you just said. Allow yourself to be correctable and be relaxed, because it's not so much about us as mediators and us as people at the table. What's the most important is the accuracy of information. So if someone does correct you in this mediation tournament, just say thank you very much for that correction and move forward. The mediation process is step by step, and we call it stages. As mediators, rest assured that even those of us in the room that have mediated many cases, coaches and judges, we may have mediated hundreds of cases or into the thousands of cases. Every time we sit down at the mediation table, we still don't know where we're going. We have no idea where the parties at the table are going to take us, and you don't either in this tournament. So we're all in the same boat. So please make sure that you try to relax as much as possible. It's the second time I've said it now, because it's your mediator style that you're allowed to be yourself. It's your mediator confidence. You have confidence in your skills, or the confidence in at least trying new skills. And it's your courage that's going to conduct your mediation today and into the weekend, into the unknown. And as you conduct the mediation process into the unknown, whether you're an advocate, client, or the mediator, you want to try to preserve the meaning that you're understanding, but you're also creating new meanings along the way. So it's very important that you pay attention to the three essential narratives that are at the mediation table. They are a person's words, a person's body language, and any emotions that may show up at the mediation table. You need to pay attention to all of them, and you need to have the confidence to move forward with all of them into the arena of, you're really upset. I just heard that you're really upset right now. How can we address your needs at the mediation table? Don't be afraid to talk about that emotional narrative that you see during the tournament. Remember, mediation is not about taking. It's not about being in court and trying to gladiate yourself into wrestling a decision for your side from the judge. Mediation is not about that. Mediation is about giving and receiving, about making an offer, but then guess what? The other side has to receive the offer and say, yes, we receive. So mediation is always about giving and receiving. Here is an overview There are 7 stages in the mediation process. We have 5 boxes here that contain 7 stages. As mediators and parties sitting at the table, you're going to hear your mediators go through the welcome and the introductions. Mediators should be talking about any matters at hand before we get started. The thing to add about the full power to make a decision at the mediation table today should also say, and without contacting anyone else. That's very important, that people do have the full power to make decisions. We're going to go through the mediator's opening today. You're either going to be saying it or hearing it, which is going to be about the process of mediation that you're going to sit through at the table today. But it's also going to be about what are the principles of mediation? What principles do we have to abide by that the mediators have to conduct the principles at the mediation table during this process? Then we're going to go into stage number 4. The parties are going to be giving their opening statements. Mediators, you should be clarifying remarks. Either your choice would be after both advocate and client are done talking for one side, you should be clarifying. Or if someone gives a lengthy opening, you should be clarifying, summarizing what you heard after the client speaks and then after the advocate speaks. It usually depends on the length of information clients and advocates give, but it's your style, it's your choice. Then stage 5 of the mediation is about setting the agenda and then the order of the speaking points of the agenda. Stage 6 of the mediation, it takes the mediation into now discussions at the mediation table, both in joint and private sessions. And I'll talk more about the private session in a moment. And then the 7th stage of the mediation is actually crafting a mediation agreement for the parties. I want to go directly into the relationship between the co-mediators during the tournament. You want to think about this relationship as a relationship about respect and poise. There are things that co-mediators should be doing. You should be splitting duties. You should be filling for each other. So when you split the duties in your mediator's opening and a mediator decides to take stage 1 and then stage 4, and the other co-mediator decides to handle stage 2 and stage 3, those are splitting the duties. When sometimes everyone's so nervous, they do the whole thing on their own and the other co-mediator doesn't have anything to do. So that means you have to fill. Filling is filling information. If your co-mediator forgets to say something that you've agreed to in the beginning of the tournament, then you say it as their co-mediator. That's called fill. If your co-mediator makes mistakes and says everything, don't repeat what the other co-mediator said just to get points. We've already heard it as judges. What you want to do is fill. And how do you fill? You fill with gratitude. Thank you very much for that mediator's opening. It was very well done. As your co-mediator, I don't have anything else to say. And now I want to go ahead and introduce the fact that it's now time for the parties' opening statements. So you want to fill. The transition statements are very important. Thank you for the introductions and the welcome. Now we're going to proceed to the business at hand. So each time you leave a stage, you say thank you for it. You talk about the stage that you're leaving, and then you transition into the stage that you're moving into. I call that opening and closing the door to the different stages in the mediation process. So if I go backwards here and you see these stages, look at the welcome. When everyone gets done introducing themselves to the table, mediators, you can say thank you for our introductions. Now we're going to proceed into any business at hand before we get started. Are there any legal orders in place that would stop people from mediating at the table today together? Does everyone have the full authority and power to make decisions without consulting someone else? To maintain our internet and privacy for this mediation, here's my email in case we get caught off guard and we lose connection. Or please, here's the link to the tournament today in case you get disconnected. For the privacy check, can we ensure that everyone is alone in the room, that no one else is there? And can we ensure, as your mediators, the privacy and the confidentiality of this mediation, that you are not making recordings? Thank you for the business at hand. Now let's proceed to the mediator's opening. These are the transition statements and opening and closing the door that allows the mediation to flow through smoothly, where everyone is safe, everyone knows what's happening. That's exactly what I mean. When you're doing As co-mediators, when you're doing the agenda, please split your duties. Splitting your duties, again, is don't be the co-mediator that talks to the parties and then writes in the chat. One co-mediator should be talking and trying to find the words to place in the agenda, and the other co-mediator should be writing it down on paper and then getting ready to put it in the chat. So you want to be splitting the duties of the agenda making. When you hear the opening statements of the parties, you may want to cross or link up with gender, as we do oftentimes. Maybe you want to summarize the opening statement from the parties, the person that's across from you on the Zoom screen. So you say so. You say, Kathleen, I see you across from me, and I'm going to be summarizing your statements of your client and yourself. Or maybe we're the same gender, and you're going to say, Kathleen, I'm going to go ahead and be the one that's going to summarizing you and your client after you make your opening statements. If you hear in the opening statements that your co-mediator doesn't say everything that was said by the parties, then you can fill and say, thank you very much for that summary. And I, as your co-mediator, I heard this as well. That would be the fill. It's also how you get the airtime in front of the judges so we can start to judge your skills. Sometimes you have someone that's a lot of air time. We call that apportionment time. You want to be speaking as co-mediators about 50-50, or it seems like you're being competitive with the other person, and you don't want to arrange a competitive feeling at the mediation table just because you're in a tournament, you're trying to score. As judges, we want to see cooperation. So please be cooperative with each other. Co-mediators in the caucus and the private sessions, you are also splitting your duties. One co-mediator needs to say, so this is your private session. We want to let you know that there's an extra layer of confidentiality, and we will be writing down what you don't want us to talk about when we return to the joint session. The other co-mediator will say, so now let's begin our discussion. What would you like to talk about during this private session that has the extra layer of confidentiality so you can be more transparent and more honest with us as your co-mediators? So you split those duties. And then you both want to summarize what you hear. In addition to agreement writing, you're also splitting the duties. You should be having a living rough draft at your mediation table, where if you hear an agreement, a partial agreement, one co-mediator wants to say to the other, please write this down. I think I heard this as a partial agreement. You ask the parties, they agree, yes, we have a partial agreement, and you're talking to the parties, and the other co-mediator is writing it down on a living rough draft. I always have one when I mediate. I always jump in when I hear a partial agreement because I have a living rough draft that I want to keep up with the mediation. That preserves meaning, it keeps the meaning, but also allows the meaning to be changed if parties want that. So this is what I was talking about. Here's your 4 steps in the mediator's welcome and the mediator's opening. One co-mediator can do number 1. Another co-mediator can do the business at hand. Maybe the other co-mediator talks about the principles of mediation. And what are the principles of mediation? You should be talking about how mediation is voluntary for everyone at the mediation table. You should be talking about how the mediation is confidential. It's 100% confidential for the mediators in some states and countries, where we rip up our notes after we're done speaking with the mediation process. You should be talking about the third thing, mediators are neutral. As your mediator, we are neutral, and we won't be making any decisions at the mediation table for you. But you also should be adding that mediation is about self-determination. There's 4 principles there: VCN, SD, voluntary, confidential, neutral, and self-determination, where you will be making your own decisions at the mediation table today. Then the other co-mediator introduces the process. So the transition statements would be, thank you for describing the principles, my co-mediator, Kathleen. And now I'm going to be explaining the process of mediation and what's going to happen today when we sit at this mediation table. Right now, we're doing our mediator's opening in our joint session. We're going to move into your opening statements, continuing in our joint session. Then we're going to be working on what you see as an agenda. And then we're also going to be discussing the order of the talking points of the agenda. Don't do them at the same time. As judges, we've seen agenda setting take 45 minutes, and we're sitting there going, really? 45 minutes? No, you set the agenda, what everyone wants to talk about, get agreement, and then you take the top two. What would be your top two? What would be your top two talking points? And then you work out the order of how you're going to be setting the agenda. Again, one mediator doing the talking, the other mediator writing things down on paper, and then entering it into the chat. And you can introduce and make those linking statements, those transition statements. Kathleen, do you mind writing this down while I talk to the parties about what they like to see as the order of their agenda? So you're working together, because two of the hardest things for us to do as judges are, number one, to judge on the co-mediation relationship, especially if no one's talking to each other. And number two, to judge on the relationship between the advocate and the client, which I'll talk about later. Then as we begin the process, you have to decide who's going to start speaking first. I allocate responsibility at my mediation table, both in court and private practice. The person that brings the case, I ask them to start talking because they brought the case today. They've asked for the mediation, so please would you begin the discussion? And then, of course, the mediators clarify what you heard. And of course, co-mediator, you fill. If I don't say everything as your co-mediator, you're going to say, thank you, Kathleen. In addition, I also heard this. Would this all be correct? You want to be corrected as mediators because you're chasing the accuracy at your mediation table. As the mediation moves forward, as you summarize for people, and this is for the mediators, but also for the parties, if the mediators don't do it, the mastery question is a question that works every single time without fail. That's why I call it mastery. Is there anything else? Maybe not in the opening joint so much, but basically when you summarize, you want to ask that mastery question, is there anything else? Because you want to get to the bottom of everyone's narrative. Because their narrative is a life force, just like the breathing, just like blood. Narrative speaking is a life force. You want to make sure that you have all the clarity all the way down to the bottom. And you don't have to say, is there anything else, over and over? Is there anything else? Might there be something you'd like to add? Is there anything else you want us to hear? I'm thinking that maybe you have something else on your mind as well. There's lots of ways to say, is there anything else? So please be creative and mix all that mastery question up. So setting the agenda, again, you're sharing what you've heard. Agenda items should be in neutral terms. They should not be specific. If somebody wants 50,000, somebody wants 30,000, then the agenda item would be, so you want to talk about money, but you get the agreement of the parties. You let them correct you as the mediator. Well, yeah, money, but the $50,000 is my money. Oh, so for now, so it's money, so it's 50,000 and it's 30,000. And get agreement from the parties as you set your agenda. So one mediator is getting verbal agreement and the other mediator is doing the writing, or you're crossing your duties where, Kathleen, will you please write down now? I want to know more about what you just said about this agenda item from the parties. Again, you work together. The order of the agenda, ask for the top two or the top three. Don't ask people for, what do you want to talk about first? It's too polarizing. So ask for the top three. I just mediated a finals at a tournament in Texas, and I literally asked, what is the one that you least want to talk about? Because as a mediator, I need flow. Mediation needs to move, and they were stuck on the first two. So I went, what's the last one that you would like to talk about? So we got our number 4 agenda point down, and then we worked our way to the 3, and then we got to the top 2. As mediators, you're looking for combinations. If it seems like agenda point number 1 and 3 kind of match each other, can we put that together, or do you want them separate? You're helping the parties flow through their talking points. So the most important, the least important, but both parties have to agree on the agenda points before you move forward. And if they get stuck, you need to help them. So as your mediator, it seems like responsibility is actually what you want to talk about. Who has responsibility here? And you get agreement from the parties, and then you move forward. The continued sessions, staying together in joint session is really important. And you don't need to interrupt as a mediator. As long as people are moving and you're taking notes about what's being said on your living rough draft or your note page, You can let parties talk. You need to summarize after a lot of information is on the table, so say so. So you enter the space with gratitude. Thank you very much for this lengthy conversation. I'd like to capture what I've heard you say. And you summarize and you turn to your co-mediator. Is there anything else that you've heard as well? And let them say no or yes and fill. And then as people are talking, you interrupt. I always teach when I train mediators, I teach them to interrupt because after each word, there's a pause. And after each sentence, there's a pause. It's called the switching pause in improvisation. And that switching pause is where you interrupt. Excuse me one moment. I think I just heard a partial agreement. And you repeat what you've heard. And if they say, both sides say yes, you say, thank you, I'm going to put that on my living rough draft. Or you say to your co-mediator, would you please put that down on our living rough draft? The parties have partially agreed to this. And that's how you make use of the information that you're hearing as the mediator at your mediation table. Private session. Why do we do it? Well, as mediators, we don't, unless we need to help our parties. The rule of 3 is what I coach. If you as mediators hear something for the 3rd time, people are going round and round, you simply say it. Excuse me one moment. This is the 3rd time as your mediator I've heard this topic. I think I'd like to call a private session so we can discuss this more separately at length with more transparency. In your private session that has the extra layer of confidentiality. See how I'm naming what I'm talking about? I'm transitioning to where we are going. And I'm going to say to the other party, I want to talk to this party first. And I'm going to say to the other party, thank you for waiting. It'll be about 9 minutes or so. Just make yourselves comfortable and we'll be back shortly. And thank you for waiting. You don't want to leave them there without talking to them because you want to open and close the door to the room they're going to be left in. And they're going to say to the party that you're taking, so thank you very much. Let's now go into our private session with the extra layer of confidentiality so we can have more of a transparent discussion. So that's going into the private session. Now, how do you come out of the private session? First of all, in the private session as the mediator, you can ask all kinds of things. You can reality check. You can say, are you sure that's going to work because of this, this, and this? And what I heard them say in the joint session was they don't want to do that. Are you sure this is going to work? You can do all kinds of things in the private session because you have the extra privacy. You want to make sure when you enter the private session, the very first thing you say is this is your private session, has an extra layer of confidentiality where we will write down what you don't want us to say when we return to the joint session. But now we're in the private session, we've got to do something. Maybe they just want it for venting. And you could say, do you feel better now that you've vented? And they're going to say yes. And then you go into the joint session. Maybe they want to talk about new information. It's your job as a mediator not to say, oh, I'll do that for you. No, it is not your job as a mediator to sign up to speak for the party when you return to the joint session. It's your job as a mediator to keep empowering them. So how would you like to share this information when we return to the joint session? How would you like to talk about it when we return to the joint session? Let them ask you, would you please do it for us? But then say, why is it that you want me to do it for you? Don't just sign up for this job because it can be very provocative if you go into the joint session with their words. All of a sudden, you can lose your neutrality because now you're expressing one party's side of the coin. So don't lose your neutrality. So when you transition back into the joint session, you simply say, if the parties want you to talk for them, you say it. The parties have asked me to speak on their behalf. Ask me to talk for them, but before you do that, you better write down what they want you to say, and you better be looking down at your paper saying, so the first point the parties would like me to say is this. The second point is this. And now, can we please have a rich discussion on point number 1? This is the information we learned in the private session that I think as your mediator, as your co-mediators, will help move this mediation forward. You want to access what you're doing all the time. So you can see here in this 3rd box, it says, if they've asked you to share, you're going to say, I've been asked to share, and I'm going to be sharing the following information. Therefore, let's see what we can do with this information now that we're here in joint session. So I've closed the door to the private session, and I'm opening up the door to the further joint session. Next screen, and I hope I'm not going too fast. How do you find agreements? Most tournaments don't get this far. because we're only judging you on what you're doing in front of us. We want what you're doing in front of us. We want it to be done to the best of your ability. Don't feel like you've got to get to an agreement. But the way that you find an agreement in a mediation in court, or a mediation in real life, I'll say, is that you keep a paper marked living rough draft. I actually pick it up like this, make sure it's below my chin, and I show it to parties. This is my living rough draft. I may interrupt the mediation if I hear a partial agreement based on your agenda points. And I write down a living rough draft, and I write things down as I hear them, and I interrupt the mediation and I say so. So when you have a living rough draft, then you can go to a pre-draft, which if the tournament gets that far, you can say, well, now I have the living rough draft. Let's go ahead and make it into a pre-draft agreement and see how this sounds as I read it aloud to you. And then in real life, court life, private practice life, I tell people that our final draft, every word will be agreeable to them. And everyone always nods their head yes. Sometimes people come into a mediation and say, I don't trust this. I don't trust these people. I don't trust this process. And I intervene as their mediator and say, what you can trust is the final mediated agreement, because every word will have everyone's permission. And you will stop me if you don't like a word that I am saying out loud, because I read aloud my living rough draft, I read aloud my pre-draft agreement, and I read aloud the final draft, even after it's done. Every word has to be okay. Words in mediation have meaning. We have to pay attention to the meaning, because a word for you, like the word, I was doing a practice round, and somebody said, oh, split. And I'm like, hey, whoa, I never said split the money. I was very offended in the role play because I didn't say split. So when you're mediating and when you're client advocating, every word is important. So be careful that you try to talk in neutral language. The co-mediation relationship, again, for the caucus and the negotiation agreement writing is the same thing. You split the duties. You are working together, but with the agreement writing and the private session, you are splitting the duties. And you're making sure that the summaries, you're summarizing everything, because of the fact that the accuracy at the mediation table is what keeps the mediation moving. You've got to chase the accuracy. So the client advocate role, what are your jobs? The client role, it's your job to act out the emotions of your story. I cannot tell you how many times we've heard as judges from other judges, the role play says you're supposed to be angry. I was looking forward to you being angry and you're not angry. What happened? If your general facts say you're angry, then please show some emotion. Please show some passion for the story as a client would be in real life. Your client role, go to your CI, make sure that you're aiming your mediation towards your CI and work backward to your general facts. Your CI is where you have to end up, and don't get there right away. So first you're acting out your general facts, but you're keeping your CI details in mind in the back of your head, because we're looking at our CI for you as judges. We're like, oh my gosh, why did they say that? Because their CI says they need to do this. So remember, the CI is very important. The advocate role, you are not just at this mediation as an advisory capacity for your client. You are at the mediation as an advisory capacity and to protect the interests of your client. And you need to tell us so as judges. We need to know that you know what you're doing. And therefore, all through the mediation, the advocates, you are protecting the interests of your client. You're also making sure that they're heard. Excuse me, Kathleen, is that what you meant to say at the mediation table right now? Oh, no, actually, you're right. So you are protecting, and you're also protecting the legality of what's happening at the mediation table, because mediations cannot write, illegal mediated agreements. Mediation has a lot of room. I like to say it can settle above or below the law, but we can't be entering into things that are criminal. We can't be entering into things like that. So as the advocate, you are the watchdog of the legality of the mediation and keeping the mediation moving on behalf of your client, but also, advocate, don't forget to reach out to the other side. This is what our interests are. Don't walk into a mediation saying, these are our demands. I heard that yesterday. Point off. We don't make demands at the mediation table. We make demands with negotiation. We make demands in court. We don't make demands at mediation. These are my client's interests, and this is what we are trying to achieve for my client. I don't know if this achieves that for my client. I don't know if that suits my client's interests. Let me take a moment and find out. And turn to your client. Be that bulldog advocate and a mediation type style for your client. The use of the mediator, hard one to score because parties don't. As the client, as the advocate, you want to be using the mediator 3 to 5 times. You want to turn Madam Mediator, Sir Co-Mediator. Could you please clarify that? Because I'm not quite sure where we are right now. You have to use your mediator. So if you're not using your mediator 3 to 5 times during the mediation, it's hard for us to judge how you use the mediator. So don't force us to make a decision that's difficult. Actively choose to use your mediator for clarification, for reiteration, for going over the agenda points, for summarizing the agenda points. What do you have on your living rough draft, Madam Mediator, Sir Mediator? Use that mediator. Let's take a pause and talk about where does negotiation enter into the mediation. This is what happens in mediation. It's about clarity. It's about accuracy and clarity. So what happens oftentimes, the clarity is we disagree 100%, 10 out of 10. I feel this way, 10 out of 10. I feel this way. You see it in the tournaments all the time. If you have disagreement, then you have to say, well, thank you for the clarity of being so loyal to your position. This is mediator speak. I'm saying it in neutral words. It seems like now we have to negotiate because we are both so loyal to our positions. Negotiation is a strategic discussion. What do you want to do and how? Because the clarity is all done in the mediation. It's all understood. Now we've got to negotiate. So negotiation is a tactical conversation, both in joint and caucus session, where you start to use negotiation tactics. You leverage, well, if we do this, are you willing to this? You do range and bracketing with money. Well, can we talk about a sum of money somewhere between $20,000 and $50,000? Would that be okay with everyone? Sometimes a mediator has to give a figure. Well, I want to throw out a mediator's figure. I do this in lawsuits, medical lawsuit mediation. I'll throw out a mediator's figure. And because I'm the mediator, people will respect it. You also can negotiate, well, we're willing to walk away if we don't even get close to this number that's important to my client. Splitting the difference is a real negotiation tactic if you can talk about the value of the split. You can't just split the difference 50-50 unless everyone's accommodating with each other. You have to be able to split the difference according to the value. So 70-30, 60-40. How do you see the value of what you want here today at the mediation table? And then positional questions. These are very powerful. Well, you don't agree with my offer of $50,000? Or what do you think is reasonable? So does that mean because you're not agreeing to this that you have limited discretion today at this mediation table? You don't have the full power and authority that you said you had? So if you don't agree with this offer, what does a win-win look like to you? These are positional questions that force people to tap into their thinking power. Would you like to concede an issue? If we concede this issue that we want here, would you be willing to concede this issue? So now you're using conceding and leveraging together at the same time. So you're leveling your negotiation tactics. What would be an offer? But please be ready for a counter offer. Don't think about just making an offer. Ask the other side for a counter offer as well. And just the if. What about if we do this? I want you to be thinking about what would be your if we were to do this. So just if itself is a negotiation tactic. Then, of course, the reality checking. You hear about the BATMA, the best alternative to a negotiated agreement or a mediated agreement. You hear about the WATMA, the worst alternative to a negotiation or a mediated agreement, but you don't hear about the most likely. What is the most likely agreement that would happen? The most likely agreement that you'd be having in real life if we did not reach an agreement today. What's most likely to happen to you if you walk away from this mediation table today? So there's 3 reality checks that you can use, not just 2. So we're going to go back to questions or comments now. I've kind of racehorse through this, so we have enough time. It's I'm here in West Texas. It's 7 o'clock in the morning. My clock says 10 after 7, which means we have about 20 minutes left or so. And we want to go ahead now, and I'm going to leave the deck up in case you want to go back to another point in the slide deck. I'll take you back there to answer the question. So Anna, welcome back. Thank you very much for moderating this.
Thank you so much, ma'am, for such an insightful and interesting session. Now we'll just take up some questions from our audience. So the first question is, how do you prevent the parties from feeling like you are being biased while reality checking in a private session?
Well, in the private session, first of all, you can be very transparent because you're 110% their mediator. So you simply say, well, let's see how this would look to the other side because we're going to go back into a joint session. That's one of the ways that you can get them to look at it from the other side. And you can say, what would be the best thing that could happen to what they could say to you when you take this to them? What would be the worst thing they could say if you take this offer to them? That's how you do it. You're exploring the options. You can say, as co-mediators, we need to explore these options with you because right now we're 110% you're a mediator. We want to make sure that we have 110% clarity here for you. Don't be afraid any point in the tournament to go directly into something by saying, as your mediator, I need to know this. I need to ask you this question. I want to make this statement and hear your answers because, again, we're chasing accuracy. We're not going to be afraid to pursue accuracy.
Thank you, ma'am. Our next question is, can a mediator make suggestions to make the final agreement more amicable?
Not typically in a facilitative mediation, but what I do is I say, if people get stuck, but I can say this because I'm in practice, I say, would you like to know what other people have decided? But for purposes of a tournament, you could say, what do you think other people might decide here with this exact same situation? Other people that you know, what do you think they might say? So you can make suggestions that way, but your suggestion is really about, let's think outside the box and come up with, because it's not working what we're doing right now. So let's try to think outside the box and see what other people might say. What would your boss say? What would your wife say? And depending upon the role play, what do you think they would say?
Okay, ma'am. Our next question is, can you describe the role of a judge in the mediation competition? Things to be remembered during the rounds.
Sure. The role of the judge is to make sure on our judge's score sheet that we're addressing every issue. That's why I asked to take out the judge's score sheet in the beginning. Look and see what we're judging. So if we're looking at the relationship between the client and advocate, you have to have a relationship. That means you got to talk to each other and share the apportionment time. That means the client's got to be the client. That means the advocate has to be the advocate, and you don't cross over. We don't want to see the advocate caring more about the story than the client does, because the client's the person who's living it. So you want to stay within your role. We're looking for you to stay within your role. We're looking for you that the CI facts come out later in the mediation, not up front, not right away. And we're looking for you to act out the general facts in an accurate fashion. We're also looking to see, what is your teamwork with the other advocate client across the table? Are you caring just for yourselves, or are you responding, asking questions? Well, how does our offer work for you? Is this going to help you meet your interests as well? So we're judging all of that. As far as us judging the mediators, we're judging how you're explaining the principles of mediation. We're judging how you're explaining the process of mediation. We're making sure that you're getting all the business at hand in place with the confidentiality, privacy checks. We're kind of checking off the boxes as to what the mediators are doing and how they're doing it, and if they're working together well.
Okay, ma'am. So our next question is, as a mediator, how do we wrap up the session?
You wrap up a session by saying what's right in front of you. Thank you very much for this mediation process today. It seems like, it looks like, it feels like, because those are all the narratives. The feeling is the emotionality at the mediation table. What's the overall emotionality? As a mediator, you can say, it seems like we've got a lot of common ground here that everyone is happy with. That would be the emotionality, the overarching gestalt of the mediation, which is the canopy of how the mediation feels. And then we've got the individual positions that people bring. It seems like we had 6 agenda items, and now we've reached an agreement on all 6. I want to congratulate everyone for these agreements. Or it seems like we've reached 4 agreements thus far, and we're looking forward to scheduling our second mediation to talk about the last 2 agreements, the last 2 agenda points, to see what we can do with that. So you're literally talking about what's happened in the mediation, which I call the trees in the forest. And you can also talk about the general canopy. The trees have a canopy, the green canopy, the gestalt of the overall feel of the mediation. Seems like this has been good. It seems like we got stuck after the first point, but don't worry. We're going to go ahead and schedule our second mediation to see if we can gain further ground in this mediation. So you describe them both to the best of your ability as mediators.
Okay, ma'am. So our next question is, for the purpose of this competition, in a 40 minutes round, is it necessary for us to take a caucus, considering the brochure specifically leaves 10 marks for the caucus? If not, how will we be marked under that strata?
Exactly. And as judges, we don't know what to do. We really just don't know what to do. I would suggest that you take a caucus, that you find a dilemma that's really happening organically at the mediation table. See, right now teams have been practicing. You don't know what's going to happen at the mediation table. Organically, you're going to run into a dilemma. When you hit the dilemma, take the caucus. When the mediator calls a caucus, when 3 times parties have talked about the same issue for 3 times, you don't have to go to the next agenda point. You can say, would you like to take a caucus now? Because this is the 3rd time I've heard this as your mediator. And actually, I'd like to ask for a caucus. Do you both agree? So the caucus is taken when parties get stuck. So you want to be careful, and you want to be sensitive to when the mediation is stuck. The caucus is the great rescue, where you can get out of the joint session, take a break and breathe and just talk with your mediator. How do we get unstuck here? That happens organically in a tournament. So it's part of the unknown journey that I talk about with mediation. It's part of the unknown, where you don't know where you're going. So therefore you have to capture that moment organically, and you just have to admit that we're stuck. And we'd like to talk about it with you, Sir Mediator. We'd like to talk about it with you, Madam Mediator. And we would like to call a joint session to discuss this issue where we can't make a decision right now at the mediation table. It's part of the unknown. So therefore, everyone in the room, your confidence and your courage and your style is going to basically predict for you how you take that caucus and when you take it.
Okay, ma'am. So our next question is, does the client make its statement after the advocate's opening statement?
You can go either way. I don't mind either way as a judge. I think it's polite and respectful if the advocate lets the client go first. But if the general facts say your client's really upset, the advocate can say, my client's really upset, so I'm actually going to start this mediation off. So that is a judgment call, and that's a team strategy that no one can really decide. As far as judges go, I can tell you that doesn't matter to me. What matters is how they talk at the mediation table and what they do with their information.
Could you kindly explain the kind of relationship the client and counsel must have as to attract the judges and so as to be a good team?
Yes. Apportionment time is how long you have the airwaves with your words at the mediation table. You want to keep your words with your client advocate about 50-50. We don't want to hear an advocate talking all this and the client basically saying nothing. So what happens is you all have to turn to each other and check in with each other to make sure that your apportionment time is almost the same. And you don't want to cross over. You don't want to have a client speaking like a lawyer. Stay in your role as client. If you're a CEO as client, I could see where you'd be a little bit more forthcoming with your authority and your poise as a CEO. But say so. As a CEO, I need to weigh in here. So you want to keep making it clear your transparency, because the more that you talk on the mediation table, the more we as judges know that you know what you're doing. We can't interpret your silence. You've got to talk to us. You've got to talk at the mediation table so we can score you.
Okay, ma'am. So our next question is, in this competition where the mediators most likely to do not know each other, will there be time to discuss how to split their duties, or they decide that during the actual session?
Anna, that's a really good question. If one of our tournament directors could weigh in on that. I do not remember reading that in the rules, but it should be in the rules. So if we don't have someone jump in here right now and help us with that question, you can go ahead and read the rules. That's why I asked you to bring the rules to the table as well, where you are. Most tournaments that I work at, somehow, some way, give about 20 minutes for mediators, co-mediators to talk to each other. So that's going to have to be chased down in the rule book. If someone cannot put in the chat right now for us what that rule is in the rule book about co-mediators having time to discuss their responsibilities and how they want to split their duties prior to beginning.
Okay, ma'am. So next question is, could you please explain BATNA and WATNA once more?
Absolutely, I'd be glad to. Let me go backwards since it's shorter this way. I think I can go backwards here. See what happens. Yes. So a BATMA is a reality check. WATMA, most likely, ML is a reality check. So we're checking if we don't get an agreement here today at the mediation table, what is the worst thing that can happen in your life if we all walk away without the mediated agreement? What's the worst thing that's going to happen to you? That's why as a mediator, I always do the most likely, because you can start with the most likely thing. On my table, in my private practice, in my court practice, I always start with most likely. So if this doesn't work out today at the mediation table, what's the most likely thing that you think is going to happen? What's going to happen? What's the most likely thing that would be happening between the two of you if you just don't come to an agreement today? So people start thinking out loud. And as people are thinking out loud, the mediator now has more information to utilize. And this is organic. We can't teach this. You have to organically hear people's words and use your, I call it mediator back brain, because your prefrontal cortex is busy summarizing everything at the mediation table, handling all the narratives, the emotions, the words, the body language. I even say, well, Anna, I heard you say yes, and I thank you for that agreement, but I also saw you roll your eyes. So now as your mediator, I'm confused. Is it really a yes, or is it maybe somewhat of a yes? On a scale of 1 to 10, Anna, what was that yes for you? Because I saw you roll your eyes when you said yes. See how I'm paying attention to body language and your words? So that's what we're doing with our brain power up here, but our mediator back brain is always finding ways to pairing, like a wine pairing, a food and wine pairing. We're pairing people's words with their agenda points. How can their words, how can we help them get to their agenda points with the words that they're saying? The BATMA is, what's the best thing that could ever happen if you walk away from this mediation table today without an agreement? What's the best thing that can happen for you? What's the best thing that can happen for them? So remember, the BATMA, WATMA most likely happens for everyone, not just for the people in the room. So you've got the best if you don't get an agreement today. You've got the worst thing that could happen if you don't get an agreement today. And you got the most likely, which is, like I said, is where I always start. That helps people reality check with, oh, maybe I do want to sit at the table longer and come up with an agreement on agenda point 3 that I've been fighting about, because the worst thing that could happen to me is awful, and I don't want that to happen to me. So it helps mediators explore more options when we do this reality checking.
Good evening, ma'am. This was really an insightful session. I just wanted your insights on the client-counsel relationship.
The client-counsel relationship, the counsel is always the protector, always protecting the interests, always helping the client maybe move their position a little bit potentially as well. Are you willing to consider this because of this, because of what they just said here? So the client is the protector, but the client is also an attorney. I always love attorneys in the room, mediation table, always, always, always. I can count on them to take care of their client. And I will say, counsel, does this meet the needs of your client? Sometimes I'll just talk directly to counsel. So the advocate, is the lawyer, and is what the word says, advocating. You're busy advocating. So every single thing that happens at the mediation table is meeting the interest of your client. The client is busy being the client. I'm so upset. I just don't have too much to say right now. Or I'm still really angry. This has not made me even angrier. I don't know what to say right now. I'm going to let my attorney speak for me until I calm down. Depends on what the general information says. Basically, that's the role. Those are the roles, excuse me.
So the next question we have is, how do you effectively handle an impasse?
Facilitative mediation always is naming what's happening on the mediation table. So I see we've arrived at an impasse. Then I would go into the meta, the intuitive of the mediation. So Anna, on a scale of 1 to 10, what is this impasse for you? And you're going to say an 8. I'm going to go to the other side. Kathleen, on a scale of 1 to 10, what is this impasse for you? And Kathleen, I'm going to say a 2. So now as a mediator, I've got one side is really at an impasse. So I always take a meta moment. Like impasse is both an emotional and an intellectual deadlock. I always take a meta moment and I go on a scale of 1 to 10 because I want to know. So for you, this is an 8. For you, this is a 10. And then I would say impasse, what would it take for you at an 8, Anna? What would it take for it to be a win-win for you? And I have people start talking. More words unlocks the impasse, at least temporarily. And then I would say, Kathleen, you're only at a 2. So what's the little bit that you need to make this a win-win for you? Anna, you're in an 8. So you need a lot to make this a win-win for you, but I'm going to allocate responsibility as I always do in mediation. So it seems like there's a lot that you need here to make this a win-win for you. As your mediator, I want to know what that is right now. Or maybe that's the point where I would take them into private session, especially in the tournament. We have an impasse here. Thank you very much for the loyalty that I'm hearing for your positions as your mediator. I'm calling for a private session because we have an impasse. And therefore, thank you for waiting. I'm going to ask this party to join me first. And you go into the private session to unlock the deadlock. That's what private sessions are for, potentially. You just go straight for it. You just name it on the mediation table, and then you try to see what it would take for them to undo it. What would make you happy? Look at these positional statements here. What do you think would be reasonable for you to undo this impasse? And you just simply use the word impasse. It has a lot of power to say that word. Words have power at the mediation table.
So, ma'am, next question we have is it mandatory for the sake of being perceived as neutral to give both parties a caucus?
No, you ask the party. If you're calling the caucus as a mediator, you know you want both of them. So you simply say, I'm going to want to talk to both of you. Is that going to be okay? And they're going to usually say yes in a tournament. But, I've been in tournaments and said, no, I don't need a caucus. I'm perfectly clear about what I want here. I don't need a caucus. I don't need extra time with the mediator. It's the mediator's job to ask. And because you're asking, you're neutral. Would you also like a caucus? No, thank you. Okay, thank you very much for that. Please wait patiently and just relax. We'll be back in 9 minutes. And you take the other team into the caucus.
Okay, so ma'am, next question is, how do you deal with a situation where the two parties are not interested in factual situation and comparison, but only bent upon showing down the other person due to ego issues, when neither side wants to back down due to ego issues?
Mm-hmm. As the best way to do this is explain what I would do in my own practice. I would say, so it seems like the facts have slipped away as being important here. Would everyone agree with that? Like our agenda item filled with these facts doesn't seem to be very important right now. I'm going to allocate responsibility for those positions, and they're going to say yes, they're going to say no, whatever it is. And then I'm going to offer them. So the tenor at the mediation table, here's the gestalt canopy feel of the mediation, is really intense and really competitive. Do we want to return back to these facts, or do we want to stay with this intense competitive conversation? Anna, do you see how I'm naming things? When you name things at the mediation table, it lowers the pressure. Whereas new mediators think, oh, I can't say that word because I won't be neutral. It's not true. You name what's happening at your mediation table, then you ask permission. It seems like the facts have slipped away. Do we still want to have this intensely competitive conversation? As your mediator, I'm seeing tit for tat. I'm seeing no clarification right now. I'm seeing you talk very quickly to each other, and this is a very competitive conversation. Do you want to keep on talking this way? Because guess what, Anna? If they want to, it's not my job to interfere. I'm going to say, I say it all the time. I push back from the table and I go, okay, keep going. As long as it's okay with both of you, it's not my duty as a mediator to become the referee, judge, and jury and go, oh, no, it's to this, it's to that. But I'm going to name what they're doing, and I'm going to ask them, do you still want to keep talking this way? They get to make the choice. That's how I stay neutral, by offering choices to both of them.
Okay, ma'am. So our next question is, shall the counsel drive the whole process, or statements shall be initiated by the client with technicals and retirement down by the counsel?
The counsel should not drive the whole process. The counsel should drive the legal part of the process.
Okay. Are there any special precautions necessary to ensure a safe mediation environment?
Yeah. Opening the door and closing the door to each stage is very important. It keeps the safety. Thanking someone for their what they've just said at the mediation table. Thank you for what I just heard, but make sure you thank the other side. The words are thank you. I appreciate what you just said. I appreciate what you just said. And this is what I heard you say. When you talk as a mediator, you give everyone room to breathe, because at tournaments, everyone's nervous. So you give the client advocate teams a chance to breathe when you're summarizing what they're saying. And then another way to be safe is let me write this down and make sure this is what I heard you say. And you take the time to write it down. Everyone's starting to relax. You keep a mediation safe by being very pragmatic, slowly, slowly, slowly. You protect a mediation by being very in tune to the meta of the mediation. So it seems like this is all very competitive right now. As your mediator, I'm going to ask that we just pause for a moment. I need to ask you, do you want to continue talking to each other this way? Because it doesn't seem like anything's happening. And see how I went right into it, Anna? You are just calling out what's happening at your mediation table.
Ma'am, so our next question is, what things should be kept in mind for drafting the agenda?
You want to keep neutral words. Agendas should not be 54 words. Agendas should be 1 to 3 words. Money, discussion about time. Agendas are short, and they are not put in order right away. You get agenda items from both sides. Sometimes, in the tournaments, the counsel goes right into the agenda items, and as the mediator, you just simply write them down. You just write them down. And then when you enter the agenda stage, thank you for your opening statements. Now we're going to move into the agenda stage. And counsel, I heard you say that you want this, this, this on the agenda. And counsel, I heard you say that you want this, this, this on the agenda. Is that still correct? And that's how you move into the agenda stage. You tell the other mediator to write it down and put it in the chat. And when I do an agenda in tournaments, I just put the first one in the chat, the one that we're talking about, but I have all the other ones written down on my paper. I don't put them all in the chat because I want to pay attention to what's being said. A co-mediation tournament, you can do that. You can have your co-mediator put them in the chat while the other co-mediator is now listening to the discussion about agenda point number 1. So you set the agenda first, and then you set the order of the agenda. You don't do them together. It's too difficult. I don't even do it together as a mediator in practice. Ever. I've mediated 1,000 cases now. I think I'm either over or just under 1,000. And I don't ever do the agenda and the order of the agenda at the same time.
Okay, ma'am. So the next question is there a particular way to deal with parties who have high status in society and may not like being corrected?
Yes. You can say, so as your mediator, I need to make a correction about what I just heard. You build context before you do it. When you build context and you tether what you're going to say in a moment to what just happened at the mediation table. Thank you very much for those honorable words. And as your mediator, this is what I need to say right now. So sometimes as a mediator, you have to push back, but it's the way you push back that's important. That's why the gratitude is very important in the mediation process, and the tethering, building context. So based on the words that I just heard you say, I'm gonna have to tell you that it seems like we have a competitive edge of this mediation table, and mediation works best when people are cooperative. I literally, in the tournament that I mediated the finals, I told one of the parties, thank you very much for how professional you are and all the information that you're giving us at this mediation table. And I need to ask you to talk slower because I am not understanding everything that you're saying. I want to make sure that I capture everything that you're saying. I literally asked someone in the tournament to talk slower. And you can do that as a mediator if you say it right.
Okay, ma'am. So my next question is it necessary to have a final draft at the end of a session considering the time restraint?
No, not ever does a mediation tournament get to the final draft. And don't even have the energy, oh, it seems like we have an agreement now. Don't do that at the end of the tournament. Don't be in a rush to do that because you're not going to be thinking well. You want to let everything just naturally flow, organically move. Mediations move, but you don't want to get into 911 mode because you think you can score 3 more points if you reach an agreement. No, we're mediating you on the quality of what's happening in front of us as judges. We're scoring you, as to the quality of what's happening.
Is there a limit to the number of times we ask for a caucus as client and counsel?
I believe those going to be in the tournament rules, and I don't know if Mediate Guru has a limit. Typically it's 1, and typically there's a 5-minute time limit for it.
Do we have to follow strictly to the time guide set out in the rules handbook?
For the caucus, yes. And for the length of the mediation, yeah. I mean, right after the 90 minutes are over or whatever is allotted here this year in our second annual, it'll end when it ends. So yeah, it'll be a hard stop for the caucus, and it'll be a hard stop for the end of the mediation session.
When is the good time to conduct a reality check during the session?
When people are stuck. Or when you hear something as a mediator, it doesn't seem like, so I'm not quite sure if I understand this. Can you please explain to me how you would walk out this agreement right now in real life? Would you please, could you walk me into how this agreement would look like when you leave the mediation table? That's how you check things out. So they say, yeah, when I go home, I'm going to write a check in a week from today. I'm going to backdate it for this. I'm going to do this and this. And then you say to the other side, is that okay with you? So you literally say, after you leave the mediation table, tell me as your mediator, how would you do this? That's another way of reality checking without saying the BATMA, WATMA, whatever, most likely.
Okay, so the next question is, would it be preferable to use first names to address mediators, other party, and own counsel?
Yes, and the mediators are responsible for this when they introduce themselves. I'm Kathleen Rowan-Leedy. I will be your mediator today. Thank you for attending this mediation. And now let's have all of you introduce yourselves. How would you like to be addressed? That's the mediator's job, to get the right name for everyone on the table and write it down and make sure you have it. So that comes out very early in the beginning. And if someone says Professor Leedy, then they must be addressed as Professor Leedy. Because that professional Professor Leedy keeps a meta distance. I'm getting very formal and professional so I can have my distance from the other people at the mediation table. That's why I would insist upon formality. For instance, when lawyers get very lawyer-like in my mediation tables, I drop their first name. I say counsel. So I heard you say this. I formalize up and I call out their role at the mediation table instead of the personal name that they've asked me to use. I go right to counsel right away because they're causing a bit of a disturbance. So I start to get very formal and start to safeguard my process.
How conversational versus formal should be the parties and the mediators be?
Very conversational. It should be just like this. It should be how we're talking. The more conversational and the slower that someone talks at the mediation table, the more cooperative it is. It's physics. It's the sound waves. They just relax. The more faster you talk like this, so I feel like you're from New York City, and this is what I want to do, this is what I want you to do, all of a sudden, it doesn't matter what I'm saying anymore. It's competitive because of my switching pauses are so close together. It's going to be competitive. So anyone that comes to the mediation table talking fast is going to ramp up the competition feel of that mediation table. And they need to be slowed down by someone at the mediation, or your whole mediation is going to go awry. Somehow, some way, everyone's going to panic because of the competitive feel of it, and it's going to run into problems. And it's the media, if they don't fix it for themselves, the parties, it's the mediator's job to do that, because the mediator's running the process. Kathleen, thank you very much for how professional you are, but we really need you to slow down, because we're just, all these words are coming out so fast on the mediation table. Don't tell me that don't insult me, but take it to the mediation table. The mediation table needs us to talk slower so we can really hear what you're saying, Kathleen.
Can the counsel state their agenda in the opening speech?
You know, you can, you absolutely can, and that's a way of putting it out on the table. But it's also a mix. It's a mix of what your interests are and what you want, and what your party, the story about what your client just said. So a lot of judges like it because, okay, now you've put that out there. But if you're going to do that as an advocate, say now, you can ask permission from the mediator. You can ask permission. You can do that one way to doing it. You can say, now I'd like to put out some potential agenda points. Don't say my demands. Don't say my agenda. This is what we see as an agenda, and I would like to go ahead and call them out. So it's the way that you do things in mediation that makes it okay for everyone at the table.
Okay, so now we have a last question. Mm-hmm. How to best leverage your BATNA and VATNA, and is there a need for only the client to reveal them?
No, to best leverage it, you can do it in Caucus where you can get the most out of people. But I like to do the reality checking at the joint session. So so we've been working very hard today, and it seems like we might not reach a mediated agreement today at the table. So either we need to schedule a second mediation, or let's talk about what this looks like when you walk away from the mediation table without an agreement. What does it look like for you, Anna, over here? And Kathleen, what does it look like for you? So when I ask Anna, what does it look like for you? And you tell me what it looks like for you. Well, the worst thing would be this, this, and this. I'm going to summarize that. I'm going to say thank you. And I'm going to say, Kathleen, what does it look like for you? And I'm going to summarize that. And then I'm going to say, okay, so I've heard you both tell me what it would look like to walk away without an agreement. See how that's a negotiation word that I'm using now? Walk away without, which is loss, loss, loss. Is there anything different now that you would like to do at the mediation table? Would you like to have a different conversation now because of what it looks like if you would walk away without it? So you just give people the choices, but mediators are naming things. We're naming the energy. We're naming what people are talking about. Our back brain is working on behalf of our clients.
Right. Thank you so much, ma'am. So with this, we conclude our today's session. Thank you, ma'am, for this wonderful session. I am sure that we all have learned something new today. Participants, hope you are all ready for the competition tomorrow. Mm-hmm. Just give your best and don't worry about the rest. All the best, guys. See you tomorrow at the competition. If you have any query, don't forget to reach out to any of the executives at Mediate Guru to get the clarity to any doubt. Thank you all for joining.
Have a lovely rest of your evening, and I wish you all well. And I'm looking forward again to seeing the teams that make it into the finals. Thank you, Anna. You are wonderful. Thank you so much. I love working with you, and hope you have a lovely evening as well. Bye, everyone.
Thank you, ma'am.